Thank you for staying with us. The federal government has commended the United Kingdom Court of Appeal for its recent decision validating Nigeria's claim for post-judgment costs in the $11 billion P&ID case to be paid in pounds sterling. P&ID had attempted to significantly reduce the total amount by arguing that Nigeria should only recover its costs in Naira, which would have resulted in a much lower sum. However, the UK Court of Appeal dismissed this claim, ruling in favour of Nigeria. The Solicitor General of the Federation and Permanent Secretary, Beatrice Jediagba, announced the court's decision, stating, quote, "Today, the United Kingdom Court of Appeal validated Nigeria's claim for the post-judgment costs to be paid in pounds sterling, which P&ID tried to reduce drastically by claiming that Nigeria should only be entitled to recover its costs in Naira," end quote. Joining us in the studio is a UK solicitor and politician, Femi Aina. Good morning.
Yes, good morning.
Thank you for joining us.
Thank you.
Now, this P&ID issue is, there are those who are saying perhaps it's uhuru for Nigeria as it is with this ruling, but you cleared that for us, and also let us understand better if Nigeria will get all the costs.
No. No.
Straightforward, no.
No, this is the way it works.
Right.
Okay? Now, Nigeria managed to set aside the arbitral award. Okay? And that was in December 2023. Thereafter, there was a court order in Nigeria's favor, because the way to work, courts follow the event in the sense that the loser will pay the winner. Okay? Now, this recent appeal is about whether that cost should be paid in Naira or it should be paid in pounds sterling. And the argument, the Nigerian argument is very simple and straightforward. And that was made clear in the judgment, that, look, this money came from the Consolidated Revenue Fund, and we pay our lawyers in London in pounds sterling. Now, the other side argument, the P&ID, their own argument is quite clear, that, look, at the end of the day, when Nigeria incurred that cost, the Naira exchange to pounds sterling was lower, because now it has gone up significantly.
Absolutely.
So because of that, it is better they pay in Naira rather than paying in pounds sterling. And now the Court of Appeal now said no, because the lawyers invoiced Nigeria in pounds sterling, and Nigeria now took Naira from the Consolidated Revenue Fund to the foreign exchange market, exchange it to pound sterling, and pay the lawyers in pound sterling. So because of that, if there is any cost to be paid, it should be paid in pound sterling, irrespective of whether there has been a significant increase in the devaluation of the Naira or not. But going back to the second limp of your question, the total cost incurred so far is £43 million. Now, the question whether Nigeria will get that £43 million is another thing, is no. And the reason why I said no is this. Now, in United Kingdom, once you finish a case and there's a court order in your favor, that court order is in two limbs. It could be on standard basis or what is called indemnity basis. Standard basis, let's say you turn around and said, look, my cost is £100 per hour. That is the standard rate, okay? It's in the civil procedure rule, how much you should charge based on your experience, location of your office, and the level of work, okay? Now, there's an indemnity basis. The indemnity basis come in whereby you misconduct, you didn't conduct yourself very well, wasting the time of the court, and the court wants to punish you. Now, instead of paying you the £100 an hour, the court can turn around and say, look, you should pay £200 an hour just to punish you. That is the indemnity. Now, once you finish, now what Nigeria is saying is that, look, the cost of work done by the solicitor, including disbursement, disbursements are costs you incur in order to process the case. Take, for instance, you go to court, you pay the court fee, then you pay somebody to go and investigate this and that. Those are disbursements. And Nigeria is now saying, look, the cost has now reached 43 million pounds, okay? And in December 2020, that's a significant amount of money, because if you change it at today's exchange rate, that is going up to 76 billion naira. That's not a big deal. The big deal is that, look, are we going to get that amount? Now, once you finish the case, you are going to prepare what is called a bill of cost, showing the work done, the level of the caseworker, the solicitor, the seniority of the solicitor. Now, you will now serve it on the other side that, look, the cost, it doesn't mean you will pay me that cost because I'm representing you. But what it means is that that is the cost you are due to pay me. That's what it means. Now, so you serve it on the other side that the liability for costs which you have incurred that you are due to pay is about 43 million. Once you give it to the other side will prepare what is called a point of dispute, whereby it is an item by item basis. Then you say on the 10th of June, 2024, you spent 3 hours reading the letter sent in by Veronica saying this, saying that. Then the other side will say, no, the hours spent is too much. And that letter could have been read by a junior lawyer. So where you are claiming 2,000 pounds, they will reduce it to 1,000 pounds. Okay? So that is the next stage in this case now. Right. Because what Nigeria is just saying is that, you see, the problem we have in this country, because we are not running an open government, somebody should have used the freedom of information to ask the Ministry of Justice or the Attorney General that how much have you paid these lawyers so far up till now. But the judge has taken a provisional view that irrespective, before any assessment of the bill, the other side, P&ID, should pay 20 million. So 20 million will come into the kitty. Then when you go to assessment, that 43 million could be reduced to 30 million. That's what is going to happen. Because the judge is going to be reducing the hours. The judge will agree that, look, if you turn around and say, look, you have the senior lawyer, you have the junior lawyer, then you have a legal assistant who is assisting you. And you, the senior lawyer, turn around and said, look, I spent 2 hours talking to this and that. Then the judge can say you should have delegated that to your legal assistant, who is charging only 100 or 50 pounds an hour. That is not a work for a senior lawyer to do. That is how you reduce the cost on item by item basis. So anybody can come to court and say it's 50 million. Doesn't mean that's what you will
get at the end of the day.
And so whether we're able to, retrieve this money, you would agree with me that to an extent this is a win for our judicial system. Earlier we had the UNODC and also the National Bureau of Statistics talk about the fact that bribery to an extent has reduced in Nigeria. How is this going to affect our ongoing efforts to address anti-corruption and other vices? And if you have any, thing to add as regards the implication on Nigeria's legal system?
Well, it has a lot of legal implication because, you see, because I practice here as well. And I must tell you, on a few occasions where I've been to court and I've seen judges in Nigeria awarding costs. And I ask myself, what sort of amount is this? Because, you see, the cost system in Nigeria, I'm sorry to say, is such that it impoverishes the lawyers. I'm telling you, it impoverishes them. And that is why sometimes the clients come into my own chamber, and I'm very worried, taking them on that, look, just go to the next door lawyers, because it won't watch my time. The reason being that, you see, the way we award cost in the UK is that, one, the judge take account of the year you were called to be a solicitor or a barrister. The judge take account of the location of your office. Because, take for instance, you are a lawyer, I'm a lawyer. My office is at Victoria Highland. Your own office is at Ibafo or somewhere. Now, the rent I'm going to pay will be higher than yours.
Absolutely.
So the court takes that into account. The court will also take into account the importance of the matter to the client. Because if at the end of the day, let's say it's a conveyancing litigation, and the client is going to lose her house, that is a matter that is very important. So it is very important for a senior lawyer to do the case because of the importance to the client. So these are the indices and the factors the court will take into account in determining how much cost should be paid. But in Nigeria, what I notice is that, take for instance, you want to amend your claim. The other side will send a lawyer that, because they are not opposing, that lawyer was just called in 2023. Then the other lawyer who is making the application was called in 1981. And the judge will just say cost to be paid by the other side is 50,000. That doesn't take account of his experience. Right. That doesn't take account of the location of his office. That doesn't take account of the importance of the case. That is why I say the legal system in Nigeria, they need to come up. You see, if you look at the civil procedure rule in Nigeria, as we speak, I was admitted as a solicitor in 2004. My rate today is £260 an hour. And within the next few weeks, it's going to go to £271 an hour. What? And I'm telling you, if you bring a case, even if you phone me and I receive your call, and I make an attendance note, I bill you for receiving that call. Because, you see, lawyers sell time. And lawyer must run cases as a business. Otherwise, you will not be there. And if you have a legal system, clients are working in, because you see, and I see this on a day-to-day basis. They come to your office and I said, madam, I'm going to charge you 300,000. And they said, this. And sometimes they said, Then I tell them that, look, if we are doing this in London, I'm going to charge you 500. They will turn around and say, we are not in London.
That is it.
Yes.
We have our peculiarities.
Yes, so you are one of them. You will say, we are not doing the case in London. But you are talking to a London lawyer. And secondly, when I live here and travel to London next week or thereafter, and I'm calling you in Nigeria, am I going to use Naira to buy recharge card? That is the question. So you see, you need to take these things into account. And it is the expertise of the lawyer too should be taken into account. It is not about just giving them money. And I must be sincere to you, they don't even run the cases in Nigeria in a very lucrative manner. So that, because, okay, look at somebody challenging the President Tinubu election. That is a lot of work. And so the president whose election is being challenged, he will have paid a substantial sum of money to the lawyers. And then by the time they finish the case and they said they will award costs and say few millions. And the client has already paid something more than that. You see, the essence of cost is to compensate you for the liability you have incurred in paying your lawyer. And the other way around, you see, look at this case now. Nigeria has won the substantive proceeding, one. There has been a cost order. There has been a cost judgment that the money should be paid in pound sterling. There will be another set of case about the assessment of that cost, which can even drag on to an appeal if these P&ID people wants to fight it. Because if the bill is assessed, no doubt the other will say cost to be paid by the other if it's not agreed. If you send your bill and your bill comes to £20,000, the other side will do a point of dispute challenging each item in the bill, then they can call you that everything is 15,000. If you agree, case closed. If you don't agree, it goes to an assessment. If the judge makes the assessment and you are not happy, you appeal again.
Wow.
Yes, because you see, that's why when you go to United Kingdom, there is a place called Fetters Lane. That's where they have the Supreme Court Cost Office. And those judges, they are cost judges. They can even tell you, bring all the papers, we like to see them. And they can say, look, it's a substantial amount of papers. And that has to be read by somebody. Because the time you spend reading That is, we call it preparation. Apart from preparation, there's a time to attend to the client because, you have to ask the client question. Yeah. And by the time you do that, you can even spend the whole 8 hours in a day, and that will be the end. And also for each correspondence and email, you see, these are resources in your office which you are using. And for each letters, if your rate is £100 per an hour, for each letter you sent out, for each email you sent out, for each telephone call you made, the client is supposed to pay you £10 for each one. And then if you have written about 500 letters, that is a substantial sum that is supposed to pay. You see, so we need to try as much as possible and make sure we have a legal system that makes cases to be lawyers must not conduct cases in a way that is not economically viable. Because at the end of the day, they spend a lot of money. If you ask the parents of these lawyers, it's a substantial amount of money to train them through the law school, the court to bar, and everything. Yeah. And then they are going into court. Somebody is giving them 10,000. Somebody is giving them 5,000.
But how did we get to this point?
How you will get to this point? That is where Parliament needs to come in, so that we have a cost rule that which judges are going to be used in making an assessment. Of course. Look, I must tell you, on one occasion, I was traveling to England, and I have a case at the Federal High Court, Ikoyi. I now called this lawyer that, can you go and hold the brief on my behalf? And he said, there's no problem, but we charge 10,000. I was alarmed. That 10,000 for what? I now said, no, make it 30,000, which was okay. But on subsequent occasion, when I now asked him to go, he said we share 50,000. I said, look, you are playing with wisdom now. It doesn't work that way. Do you understand me? Because you see, nobody will give me such an amount to represent them. I won't go because it doesn't worth my time. And if you sit in your office, as any lawyer, you make more money than when you go to court. When you go to court, the only skill you get is that you are learning advocacy because you are seeing argument for and argument against. But when your rent is due, when the bill is due,
you cannot argue with the landlord.
You can't argue with the landlord. So that is how it works. And we must commend the Attorney General. We must commend the former Attorney General Malami because he was the driving force behind it. And by extension, we must commend President Buhari himself and by extension, President Tinubu as well for carrying the cases on. But for now, at least the money they've taken from the Consolidated Revenue Fund is coming home. But what will happen in the long run is this. The lawyers are now saying the cost in court so far is 43 million. When the matter go to an assessment and they tend up to be assessed at 30 million, then there's about 13 million left. Then at that point, the lawyer will now decide whether they want Nigeria to still pay that to balance the book or they want to write it off. So that will be a matter for negotiation, but it doesn't mean the 47 billion or 43 million pounds is coming. But at least for now, one thing that is certain is that about 20 million pounds will be paid because this is a substantive case. This is a case that's been going on since 2006 or 2007. And you see the level of the lawyers use. Some of them will charge about £1,500 an hour. And they will still charge for refresher. And the refresher comes in, let's say you've been to court in January, and the court adjourned the matter till June. Then you won't just wake up in June and just go to court. You still need to read the papers. And then you still need to charge for it. So, it might end up just little bit. I was training one lawyer, and I said, look, now you've read it, have you? Do your attendance. How many hours did you spend? So it is the little drop that makes the mighty ocean. Absolutely. Yes, little bit by bit. By the time you, at the end of the day, the bill might come to £12,000. It could come to 20,000. And by the time you negotiate, you get about 18,000.
Should have studied law.
It works.
I'm wishing I studied law.
Quite interesting. Let's talk about whether Nigerians have actually, Nigeria itself has learned its lesson from this whole thing. I believe this whole thing began because someone decided to take advantage of some of the lapses that we see in the system.
Yes.
Public servants, others also brought to book. so many persons receiving bribe, especially some other problems affecting the oil region. So have we really learned our lessons to avoid future P&ID cases?
Yes, we have. And I think there are lessons to be learned, okay? And one of the judges, I can record in this P&ID cases in the UK, actually advised Nigeria that when you have cases of this nature, it's very important. You get people who are
experts,
very competent, experts,
yes.
And what that you get experts, you get people who are very competent. Because what happened in this P&ID case, unfortunately, they are asking for about 6.6 billion. Assuming we lose the case, that's a lot of money.
That's a lot.
And then you have the government saying, look, we want to tackle poverty. Why will you tackle poverty if you lose about 6.6 billion? It's a significant amount of money. But some people receive bribe. Public officials, they were bribed. The people who enter into the contract, they even stole, you see, when they did the presentation for the proposal, it was an idea by somebody else. They stole that and just manipulated it and put it forward. There are a lot of things that went wrong. And it is unfortunate that I think some of the people who collected the bribe, I think one of them is dead. There are others who are supposed to be charged to court. They have not been charged. Then the lawyers who were used to, they were even criticized because they took this laissez-faire approach towards dealing with the matter.
With the case,
and
yes.
it just ended up in a situation whereby even some of the judges were very concerned that how could you do this to your nation by somebody has given you a brief. You are not even fighting with from all fronts. What you just did, you were sitting in Lagos, so write some funny things and send it. That doesn't even address the issue. It is just like, you will know it is a very corrupt system. And they realized that some of these P&ID people, even at a point they were saying, they have paid to Cross River State government a substantial amount of money to acquire. And the Cross River State government said nothing has been paid to us. And these are what they are putting across the court. And assuming we lose this case, I must be sincere to you, there are a lot of people who will have benefited a lot because the case is insured and it's being financed. And those people are supposed to take a substantial amount from whatever is awarded against Nigerian government. So they are the people who are pushing the case. But thank God, Malam, irrespective of all the criticism about his tenure, he really did well by carrying out extensive investigation to get to the bottom of this.
Those who were to benefit from it, were they also Nigerians?
No, those who are to benefit, some of them are in London, and they are the third party who are financing the case. That, look, when you win, because sometimes lawyers do cases on what is called contingency fee, whereby I will not charge you money, but if the money drop, I will take 40%, you will take 60%. That is what you call contingency. And then, there are other schemes as well, whereby you can insure the case, then you can tell the client, or you pay by installments as we go along, because you don't know how long it's going to go.
It's going to go
but
for.
there are a lot of lessons to be learned to avoid this sort of situation. And
Absolutely.
they are dealing with that at the top level. I must be sincere, because I've read in the media that, look, all this sort of contract, once you get it, send it to the Attorney General office, they will set up a panel and
to scrutinize it. Yes, it's important. But my concern is the aspect of our legal system. You have talked about the implication for us and all, but how we need to rework the system such that it becomes what it should be. Because at some point we saw where people were, criticizing the legal system and not even being the hope of the common man at the end of the day. And you have mentioned a whole lot how, the system runs in the UK. And we know a lot of persons who are even in the Nigeria Bar Association of traveled, they know what goes on. But how it is that it's been difficult to entrench, these practices in our system is mind-boggling.
No, it is. And honestly, between me and you, the Nigerian legal system is not user-friendly. I must be sincere to you. It's lawyer-driven. It's lawyer-driven. If you go to court at Federal High Court Ikoyi today, you go to the High Court at Ota and all other places, it's only lawyers you see there. You don't see litigants in person as you see in United Kingdom. There are some people, I'm telling you, some of them are retired. What they do every day, they go in the library and be reading law book. And if they get into a nasty divorce with their wife, they come to court with a lot of books, a lot of authorities, okay? And I must be sincere, it's such, go to the Royal Court of Justice. There is a charity there who is helping ordinary people to navigate the system. Because, you know, it's a very big body. And they ask you, go to beer garden, go to this. But you see this charity with their badge, they are following you that this is where you lodge the paper. They are not giving you legal advice, but they are assisting you. Because, you see, some people are very nervous to come to court. And you still get others. You can even get a QC or SAN about 5. Then you get one litigant who is fighting to death. It's not legally qualified, but he has researched the people. And there's something you call the shampati or unbundling, whereby you have a case. I don't need to represent you, but when you get anything from the other side, just bring it to my office. I help you to write. You go and file it. That is what. So we need to make our legal system to be user-friendly. We need to make sure that it is not too restrictive unnecessarily. And we can use form. We can have a system whereby judges, they are not wearing their wig and gown in dealing with ordinary people. That's the way forward.
We'll leave it here now. UK solicitor, politician, Olufemi Aina, thank you so much for your time.
Yes, thank you for
on the program.
Yeah, thank you.